right, this is case number 21154940. This is Affiliated Diagnostics of Michigan, strike out of Coleman versus City of Detroit. Looks like the matter is set on for a pretrial hearing. Your appearance at this time for the plaintiff, please.
Good morning, Your Honor. Michael Fergustrom for the plaintiff, bar number 48864.
Thank you, Mr. Fergustrom, and good morning to you. For the City of Detroit, Counsel.
Your Honor, I'm sorry. I think this is my case, but I had a little glitch in the stream there. Could you give me the case number again?
Yeah, this is Affiliated Diagnostics versus City of Detroit. That's a suffix of 4940.
Well, I have an affiliated diagnostic case, but not with that number, Your Honor.
All right, and this one, one other thing I wanted to point out about this one.
And Mr. Patterson, he went to, he said he had to go sign in. He'll be right back.
Yeah, Mr. Patterson's case. So, Mr. Ferguson, Mr. Patterson stepped away. Anything you need to bring to my attention at this time? Do we need his presence today?
No, Your Honor. Obviously, I think we probably need Mr. Patterson to go any further. And I know he checked in. Obviously he had to move away for another matter.
All right, very well. I will come back to your matter, sir.
Thank you, Your Honor.
All right, this is case number 211-55417. This is Jefferson Capital Systems LLC versus Elizabeth Miller. The matter is before the court. Looks like it's set for the general hearing on today's date. Your appearance for Jefferson Capital, please.
Morning, Your Honor. Sean Bodwine, P71644, on behalf of the plaintiff.
Thank you. Good morning to you, counsel. Do I have Elizabeth Miller on this Zoom at this time? Elizabeth Miller?
Yes. Hi. Good morning.
All right. Good morning to you, Ms. Miller. All right. So I don't have a complete file on this. So, counsel, why don't you update me, if you will, sir?
There was a judgment entered on 8/30/21. I don't know, at some point a answer was filed. I think that's why we're having this hearing.
All right, just one moment. Yeah, all I have is a register of action, so let me see if I can get something else here.
Yeah, someone else, I don't know. I didn't enter that court date. I guess it was one of the days I was off.
Right.
I didn't have to file. So they set it for today at 9:45. They give me anything else.
Yeah, I don't have anything else but the register of action. So it looks like the judge now, and I don't even see the entry of the judgment. I see that there was a judgment presented, and that judgment was somewhere in the nature of some $1,300 that was being requested. All right, so Ms. Miller, I don't have a complete file. Did you file something in regard to this case, ma'am?
No, I did file bankruptcy. This was maybe a couple of years ago, a year or so ago.
Okay.
Let me go down and see if I can find. I tried to.
Was this one of the cases that was this one of the debts that was included in your bankruptcy filing a couple of years ago, ma'am?
Yes.
All right. So we're going to try to find the file on this to see exactly what is going on here. All right. So just hold tight, ma'am.
Okay.
I do see 8/24/21 on that register of action says something about defendant's answer sent with the file to the Judge Coleman for review. So did you send in a document on this case?
Yes, the person that filed the bankruptcy, I believe she sent it to.
Okay.
It
So
was
I'm talking,
on the.
oh, I'm sorry, I cut you off, man. What did you say?
I say I know it was on the list as one of the under my bankruptcies.
Okay, okay, but when you received this case, that was filed against you, did you file something with me or send to this court anything?
No, sir, I didn't. I just received this letter in the mail.
Okay. All right, so I'm gonna try to get my hands on the file so we see where everything is. So just hold tight for just a bit, Ms. Miller, and so I'll come right back to you. My clerk is looking for the file now. This was set up on a day that she wasn't here, so we're gonna get that file and then we'll be able to take some action. So just hold tight, everybody. I'll come back to that.
Thank you.
Okay.
All right, the court now is calling case number 21-65615. This is Affiliated Diagnostics of Oakland versus City of Detroit. This is again file number ending in it's 21-65615. I also have United Lab and Select Specialist versus City of Detroit. That's under file 21-155-250. Both matters seem to be set on for pretrial and/or a motion hearing. Counsel, your appearance regarding regarding Affiliated Diagnostics of Oakland, please.
Morning, Your Honor. Patrick Cunningham on behalf of the City of Detroit on the affiliated diagnostic case.
And good morning again, Your Honor. Michael Fergustrom for the plaintiff.
Okay. All right. So, Mr. Cunningham, your P number for the record. I have Mr. Fergustrom's P number. Go ahead.
Thanks, Judge. It's 67643. And Ms. Porter from our office is on the other case, so I'm not representing the city in that case.
All right, thank you. And on this board, I'll be right with you on that one. Okay. All right, so I see that I think I set this over for a motion hearing on today's date. Is that correct?
Yes, Your Honor.
All right. All right, so I'm seeing the defendant's motion in this matter. I don't see a response, at least a written response to that motion. Counsel?
My office did submit a response, Your Honor. I've been a bit away from things. We've had a death in the family this week and another one, unfortunately, imminent. But I did see that a response was filed.
All right, I don't have the response. If you will, counsel for the city, Mr. Cunningham, go ahead on your motion. Let me hear the general nature of your motion, if you will, sir.
Sure, Your Honor. The general nature of the motion is that the city never heard anything from Tanisha Norwood Adams regarding a PIP claim. We got a letter from her lawyer that said, we're going to make a claim. Our office sent forms to allow Ms. Norwood Adams to make a claim and never got the forms back. No claim was ever made. No proof of her loss was ever submitted to the city. I don't think the bills that the plaintiff in this case was seeking were ever submitted to the city other than through this lawsuit. Plaintiff has never established that Ms. Norwood Adams had no other insurance. The city is an insurer of last resort for bus passengers. There's no evidence in this case that Ms. Norwood Adams didn't have some other insurance. She never completed her claim with us, which makes it possible that she had some other insurance. And Your Honor, I guess the burden is on the plaintiff in this case to prove that, and there's been no evidence submitted to accomplish that.
All right, and is there a 1 year back problem here, or is this simply that there was that predicate for the claims are not there?
There is not a 1-year back problem, Your Honor.
All right, thank you.
The
All right,
lawsuit was timely filed.
Thank you. Mr. Ferguson?
Well, Your Honor, the defendant is conflating here the burden of proof at trial with the standard for summary disposition. As I'm sure the court's aware and is stated in our response, although unfortunately the court doesn't have it before it, for a motion under 2.116C10, the defendant has to initially submit substantively admissible evidence that demonstrates the absence of a genuine issue of material fact or negates an essential element of the claim. In this case, the defendant hasn't offered any evidence in that regard. What they've merely done is challenge whether my client can meet its burden of proof effectively at trial, which is very different from the standard for surviving summary disposition. Whether Ms. Norwood Adams submitted her own claim or not, my client has an assignment from Ms. Adams in this case, as well as a statutory right to bring its own claim under the revised No Fault Act that was enacted in the summer of 2019. The factual issues that the defendant has raised, albeit without submitting any evidence to support them, are matters that should be addressed in discovery, not something by which they can simply come to court and say, we challenge the plaintiff to meet its burden of proof, or we don't think the plaintiff can meet its burden of proof. There's been no evidence submitted by the city that would negate any element of my client's claim at this point. Mr. Cunningham says he thinks that my client didn't submit bills to the city. It appears otherwise from my file, but regardless of that, whether Mr. Cunningham thinks that or not, there's no evidence in that regard submitted here by the defendant. And under Maiden versus Roswood and its progeny, those cases state that unless and until the defendant meets its burden of proffering substantively admissible evidence that negates the possibility of a genuine issue of material fact, the plaintiff has no obligation to even respond, because what we're supposed to respond to is that evidence. And so in this regard, they simply have not met the threshold requirement to even have a motion for summary disposition entertained at this point. And I would ask that the court, on that basis, deny the motion for summary disposition.
It does seem that, Mr. Cunningham, that you're alleging that there are certain predicates that have not been met that would make the complaint in this matter, that would be fatal to the complaint in this matter. I.e., it seems that we inferentially state that the plaintiff would have to allege in their complaint that all other options for first-party benefits have been exhausted, and that the city, of course, is the final resort, and that it seems that that has not been alleged in the complaint. That would be the basis to say that without those allegations, the plaintiff could not survive under circumstances where there may be some other entity obligated and where the city has not been otherwise put on notice. I think that's the argument that you're making. Tell me why summary disposition is not premature.
Sure, Your Honor. First of all, discovery was closed. I sent interrogatories and requests for production of documents back in March of 2021, and I didn't get a response. Second of all, I filed my motion in August of 2021, and it's being heard, several months later. This is actually our third date that was set for hearing on this motion. The time to come up with evidence was today. What I've produced, Your Honor, is there isn't any evidence. And so today was the day to come forward with evidence that says there is no other insurer and there is no evidence to show that, Your Honor.
If I might add one other thing, Your Honor, the possible existence of other insurance is not an element of a claim. Negating that possibility is not an element of a no-fault claim. That is actually a defense to a claim, and not something that the plaintiff is ever obligated to prove as part of its case in chief. The mere possibility, and that's all that we have here, is Mr. Cunningham saying we don't know if this person has other insurance. Well, that is not even close to evidence that she does have other insurance, and that is what would be required for that to be a viable defense here.
Right. It seems to me that Mr. Cunningham has indicated that he made certain discovery requests and that those requests were not timely met, and that discovery is closed now.
I guess I would say to that would have been the subject of a motion to compel. I'm not aware of the discovery status of the case, frankly, but the failure to answer discovery, even if that happened, and again, I'm not aware of it, is also not a basis for summary disposition. If there should have been a motion to compel if we somehow dropped the ball on answering discovery, but there's no law in Michigan that says a mere failure to answer discovery, absent, say, a violation of a court order, provides any basis for dismissal or summary disposition of a case.
Your Honor, that was just in response to plaintiff's argument that more discovery might sort this out. The opportunity for discovery has come and gone. Today is the time to produce the evidence, and plaintiff hasn't produced it.
What is it that you have to go forward on, Mr. Ferguson?
You mean in terms of evidence, Your Honor?
Yeah, assuming for the sake of argument, as has been indicated here, and I'm looking at the file, that discovery is now closed in this matter. You made certain allegations in the complaint, and there's been nothing to buttress any of that at this stage of the proceedings. So what gives you the right to continue on in this matter where there is no showing that other insurers have been excluded, where the city would be the insurer of final resort?
Well, first I would say, Your Honor, I mean, I've tried some of these cases. I've litigated many of them. I've never ever had a court require the plaintiff to prove that there was no other insurance available. This was a bus accident, as I understand it. What we have is the fact that Ms. Norwood Adams sought medical treatment from medical professionals, told them she was injured in this motor vehicle accident, which is admissible under the hearsay exception for purposes of medical diagnosis and treatment, including the inception or cause of the matter being treated for. She indicated to Affiliated, and her medical professionals prescribed the MRIs that Affiliated performed. She also, in her intake with Affiliated, as I recall from the file, indicated that she was being treated for injuries sustained in this motor vehicle accident. Those and issues such as the reasonableness of the pricing, the reasonable necessity of the treatment are the elements of a no-fault provider claim, and the city is not challenging any of the absence of any of those. They're talking about the mere possibility that there's other insurance, which hasn't been excluded. And again, it is not our burden to exclude that. That is not one of the elements of the claim. It is a defense issue. And if the defense finds that there is other evidence applicable, that is a defense. But it is never the plaintiff's burden to root out or negate the possibility of any other insurance. It's merely speculative at this point for Mr. Cunningham to say maybe there's other insurance. We don't know. We simply do not have to prove that even at trial, much less at the summary disposition stage when the defendant has proffered no evidence that there is other insurance available.
Your Honor, I don't think that's consistent with the statute.
Let me stop you. Mr. Cunningham, you get the last word on this, sir.
Okay. Thank you, Your Honor. So MCL 500.3114 is the priority statute. Section 2 says a person who suffers accidental bodily injury while a passenger of a motor vehicle operated in the business of transporting passengers shall receive the personal protection insurance benefits to which the person is entitled from the insurer of the motor vehicle. And it says, this subsection does not apply to a passenger in any of the following unless the passenger is not entitled to personal protection insurance benefits under any other policy. That places the burden on the plaintiff to establish they are not entitled to personal protection insurance benefits under any other policy. This isn't a case where you would prove, oh, I have a policy, and then they would submit affirmative proof of that. And then if I said there's some other policy, that would be a defense. This is a case where in order to be entitled to benefits from the city, the plaintiff has to establish that she's not entitled to personal protection insurance benefits under any other policy of insurance.
All right.
And Judge, how we would normally do that is an affidavit or deposition testimony from the person. And that's exactly what we don't have in this case.
All right. All right, the court has listened to the arguments on the motion for summary disposition, and the arguments presented are set forth well on this record. The argument is grounded in MCR 2.116 CT, and wherein the defendant in this matter alleges that there is no genuine issue of material fact, and that the defendant therefore is entitled to judgment as a matter of law in this case. It appears to me that while this is something of a close question, it does appear to me that the plaintiff has to right to go forward and present evidence as to whether or not that particular predicate exists or does not exist. And certainly to the extent that it does not exist, that would allow for the granting of summary disposition or some other form of dismissal of the complaint. And while it has been brought to my attention, certainly that discovery is indeed closed on this matter, the court is not inclined to reopen discovery. And the court may very well entertain other motions that address issues of proof in this case. At this point, I don't think that, based upon what I've heard, that the defendant is striking the plaintiff is forestalled from being able to present a case in which the city may very well be the only assurance available. If that is not in fact the case, then the case will ultimately be dismissed anyway, as there would be someone of higher priority. For that reason, I'll deny the motion for summary disposition at this time. And I would have to indicate that that denial was without prejudice. The motion is denied at this time.
Thank you, Your Honor.
Thank you. All right, good day. All right, we're on the record in the suffix 5250. That is United Lab on Select Specialist versus City of Detroit. Your appearance for regarding that matter.
Good morning again, Your Honor. Michael Fergestrom for the plaintiffs. My bar number is 48864.
All right, thank you, sir. I didn't know you were on that one. For the city, if you will.
Yes, Patricia Porter, P66989 for the City of Detroit.
All right, thank you, counsel. And so somebody update me on this one. I do see the answer and everything. Looks like that was October the 27th. So this is everything's kind of recent here, correct?
Yes, Your Honor. There has been some discovery. The city did issue an initial disclosure. There is still a discovery outstanding. Depositions have been noticed on both sides and they haven't been scheduled yet. So we are going to need a little more time.
All right, very well. And I know I set it up for status conference on a previous date. Did I in fact formally open discovery previously?
I don't think you did. However, we did engage in discovery.
Excellent, excellent. All right. Mr. Bergestrand, anything at this time, sir?
No, Your Honor, I certainly have no objection to Ms. Porter's request for more time so that we can complete discovery.
All right, so what I'm going to do is I will open discovery for a 60-day period, and I'm only doing that so that I can get you back in here to see where things are after that time. If two experienced attorneys tell me that they need some more time, then when you come back, I'll consider that at that time. So you've already begun the process, so I'll just open it up formally for the next 60 days, just so I can have control dates there. You come back on that date, we'll treat that as a final settlement conference. But again, if you need additional time, I'll consider that at that time. I'll give you some dates and just on the final pretrial date I'm going to give you. You can file motions to be heard on that date, dispositive and otherwise, so long as you allow the opposing party at least 7 days time to respond before the hearing. So I'm shortening the time for filing such motions, even if it's a dispositive motion, as long as you file it and give the other side at least 7 days to respond before the hearing, at least 7 days before the hearing to respond, and I'll hear it on the final pretrial conference date. That way we don't have a delay in filing motions. If you want to do that, if you believe that there's something that is dispositive that gets right to the point, then you could file it, and I'll hear it, notwithstanding the short time. All right, so 60 days out is going to give us a close of discovery, and actually it's going to be a little bit more than 60 days anyway, because I'm going to give you open discovery up until the final pretrial conference date. So that date is going to put you into late January. So I'm looking to bring you back on the 27th of January, 2022. 1/27, 2022, and that's going to be at 9:30 a.m. You'll get an order from me that opens discovery through that period of time, and it gives you that particular court date, and it also has the language regarding the filing of the motions if you wish to do so. And I'll review everything at that time. Right?
Thank you.
Yes.
Good day to both of you.
Thank you very much, Your Honor. Have a good day.
Likewise.
That file was not there. I went down the file for the yellow. I went through again.
Okay.
I'll find it.
Thank you. And I'm back to the suffix 5417. That's Jefferson Capital Systems LLC. This is Elizabeth Miller. We are not able to really locate the file in this matter. And Ms. Miller, Counsel, has there been any checkup on this thing? If not, this might have been the subject of some bankruptcy, or you don't have any information in that regard?
Could not find any record of any bankruptcy being filed.
All right. So, ma'am, I don't have the file, but I know that they're seeking a judgment against you in the amount of $1,337 plus court fees in this matter. And the case has you in default because you didn't submit an answer to the claim. Anything you want to tell me about that?
You said the balance was what? Because I've been paying them that money a little at a time, much as I can since that occurred, since they got the car back. So what is the total again?
The total that was alleged in the complaint was $1,337.32. That would be a little bit higher than that. And Council, you may have a number with court costs and stuff, if you will. What number do you have, sir?
Total amount is $1,517.81.
So they cite that. So you hear that amount. And I know there's a lot going on here. I want to take a moment and see if maybe you could reach some type of resolution of this. And you have any idea of what you think the amount might be, Matt? Or you have an offer you want to make? I want you to think about that. And I'm gonna send you and the attorney to a breakout room so you kind of talk through this a little bit and see if there's a compromise that can be reached. If not, we'll come back in the courtroom and we'll figure something out. But let's see if we can get this resolved. Because it seems to me that you're not really disputing the debt on this, that there was a car that was repossessed and there's some money that's all you said you've been paying on some of it, correct, ma'am?
Yes. I believe they took my taxes a couple of times before. So that's
All right.
why it's at that price right now, I believe. So
All right.
a lot of
Well,
funds that's been taken out my checks when I was working also.
All right, got you. Well, let's see if we can come up with an amount that maybe will work for you and work for them, and maybe even a payment plan to try to get this resolved. So I'm going to put you in a breakout room. You're going to get a notification from me to breakout room 1. Just click in, and the attorney's going to meet you there, and see if you can talk about it. If you can't talk it through, just come back in and we'll figure something out. Understand?
Yeah,
Okay.
I just want to make it clear, this is a new case. We have not done any garnishments or anything on. We just received the judgment in August, so.
All right, and and you could, if you will, go over some of that with Ms. Miller as well, and then see if there's room to some compromise. They believe this would be a different case that doesn't have a history of any garnishment, so he's going to tell you where this case arises from, so we can see if we're all on the same page. So here's your notification, ma'am, and counsel, I'm sending you a notification to breakout room 1 as well, sir.
Thank you.
Mr. Patterson, I'm glad this. Now, Mr. Cunningham, I thought I saw Mr. Cunningham back. Cunningham?
No, Your Honor, Mr. Cunningham was on a prior case. I had to excuse myself to check into another courtroom.
Gotcha. I thought he was back because I didn't set a subsequent date on that matter where the motion was denied. But Mr. Ferguson is still here, and we'll go ahead and set a control date on that matter, and you'll make sure.
Your Honor, I don't believe our case has been called yet. I'm here on.
Mr. Patterson, I'm coming to you, sir. I'm coming to you. You're on the suffix 4940, is it?
That's correct, Your Honor.
Yeah. I called that one. I'm coming back to it in just a moment, sir.
Okay, very well.
So, Mr. Ferguson, I'm going to set a control date for the previous case, the 5615. In that case, a motion for summary disposition was denied. The court is going to set that matter on for hearing on the 13th of January, 1/13/22. I'm going to set that on at 9:30 a.m. I'll set it for a final settlement conference. All right.
Thank you, Your Honor.
You'll get a notice from me with that date on it, but I just wanted to get it to you and you could perhaps convey that information to Mr. Cunningham as well. So, thank you.
I'll make a note of that, Your Honor. Thank you.
Good. We're back on the record regarding the suffix 4940. That's Affiliated Diagnostic Oakland LLC versus City of Detroit. Mr. Ferguson, you've indicated your appearance together with your P number. You may at this time for the City of Detroit, sir.
Good morning, Your Honor. Gregory Patterson, P75963 here on behalf of the defendant, City of Detroit.
All right, Mr. Patterson, thank you, sir. Thank you for your patience in this regard, sir. All right, so it looks like this is set up today for pretrial, and then I have it indicated as a motion hearing as well regarding this matter. So, Mr. Patterson, why don't you update me on things here, sir?
Yes, Your Honor. This is time and date set for the City of Detroit's motion for summary disposition pursuant to MCR 2.116 C10, premised upon fraud or absence of identifiable injury, or in the alternative, our motion for security of cost pursuant to MCR 2.109. This case arises out of a motor vehicle accident occurring on May 10th of 2020 involving a passenger by the name of Malik Preston. During the course of our investigation of this case, we came to suspect that Mr. Preston and this claim is part of a larger scheme to fraudulently obtain insurance benefits from the city of Detroit. And it is premised upon a series of cases involving very, very minor motor vehicle accidents in which we believe that accidents are staged and involve a vehicle intentionally striking a City of Detroit bus and then fleeing the scene. In our motion, we identified a select number. There are, at this point, I believe, upwards of nearly 50 different claimants in similarly situated circumstances. Of the examples provided in our motion, Affiliated Diagnostics has been the treater for, I believe, 2 of the 3 identified in the motion. We're still compiling a complete list. And I do believe, Your Honor, that in this case, the video evidence, which I would very much like to show the court, is determinative as to the nature and the fraudulent nature of this action.
Wow, that's a mouthful. Mr. Ferguson, I take it that you've, and I don't mean that to diminish it, when you said that there are upwards of some 50 cases that seem to be similar, 50 situations that seem to be similar, that's a mouthful there, yeah.
Yes, Your Honor. It's been a substantial investigation on the city's behalf to kind of comb through all this. But I believe, again, with the video evidence, the court will understand fully our concerns.
Thank you, sir. Mr. Ferguson, do I have a written response? Go ahead, sir.
No, Your Honor. And this one, as I said, I've been operating at a rather low ebb, and this one was actually put on my calendar only as a pretrial. I discovered only this morning when I spoke to Mr. Patterson that this motion was up, and and I was able to locate it and read it, and apparently nobody in my office thought it was a pretrial, and nobody picked up on the motion. What I would say is the rather lurid tale of someone intentionally striking the bus with a car in a hit and run accident, with passengers on the bus being part of some sort of fraud conspiracy is regarding the other cases that are listed by Mr. Patterson. They have nothing to do with this case. Whether there was or was not fraud in any of those cases, I have no idea. I'm looking only at this case, and it's entirely speculative for the city to say we believe that passengers got on this bus and had an accomplice ram the bus with a car and then speed off as part of a fraud claim. Fraud is something that has to be proved by clear and convincing evidence, and there is nothing here but speculation and suspicion. As far as affiliated is merely an MRI facility that does MRIs by prescription of plaintiff's doctors. And so in terms of this alleged conspiracy, which I don't think has been proved by any substantively admissible evidence here, that has really no bearing on affiliated. There's certainly no proof that affiliated is somehow part of this, rather elaborate scheme that the city seems to suspect is going on. But again, the list of other cases and other patients or claimants who have been involved in bus accidents that the city suspects were staged simply doesn't prove any sort of fraud in this case. And even as to the video, whether the court reviews it or not, I think what the city is asking the court to do is say, look at what happened in the bus. We want you to rule as a matter of law that this person was not injured. And I think that is not something that the court can do as a matter of law merely by looking at a video. The patient was treated by medical professionals, by doctors. They prescribed MRIs that my client performed, and that's what my client does. As with a pharmacy providing a prescription, it gets a prescription from a doctor, and it does what the prescription says. The idea that the court or I, as a layperson or any other layperson, can look at a video and say, we're concluding as a matter of law that this person was not injured in the accident is a leap that I have never seen any court take. And I don't think that it's one that can properly be taken. If there is some sort of massive fraud scheme, I wish the city luck in proving it and putting a stop to it, but there's no proof in this particular case that the accident was staged or fraudulent, and certainly no proof that Affiliated had any knowledge, much less complicity in the alleged fraud. So I would simply say at this point, and I apologize that my office did not do a written response here. I'd obviously like an opportunity to do that, but even with what we have before us, I don't believe the city has come close to establishing something that would allow dismissal of the case at this point.
Well,
If I may respond, Your Honor.
Yes, sir, but not yet. So it seems to me that what Mr. Patterson is in fact asking you to do is to draw some conclusions that might be far-reaching, but that certainly would be significant to the extent that there is a predicate of fraud that's involved in this case. But, Mr. Ferguson, you raised the issue of the clean hands of Affiliated Diagnostic. And it does not appear that Mr. Patterson or that the city of Detroit has alleged that Affiliated is involved in a fraudulent scheme. That has not been alleged before this court. But that would not be consequential because there's a sense in which Affiliated Diagnostics stands in the shoes of Malik Preston. But again, I think that the issue that is raised here is that if Malik Preston has a fraudulent scheme going on, then then that could mean that Affiliated has been fraudulently schemed as well, and that but it would not inure to the responsibility of the city, Mr. Patterson, I believe is arguing, to pick up for services provided to someone who is engaged in a scheme. Mr. Patterson, you may at this time respond, sir.
Yes, Your Honor, I have three notes here, and the first one is you took the word right out of my mouth, that whether or not Affiliated had any involvement, and you're correct, there's no suggestion that there is any direct involvement. They do stand in the shoes of Mr. Preston, and certainly if he engaged and participated in a fraudulent scheme, that would bar any of his peers from recovery. The second note was that there is evidence of fraud, and I do believe the video is certainly worth noting. And third, I understand Mr. Fergstrom's position as far as asking this court to rule on a matter of law premised upon a video, which is why we gave the court or presented the court with the alternative of a motion for security of cost, which is a viable alternative where the court has significant doubts or suspicions about a claim, but might find it inappropriate to rule as a matter of law. So we did offer that as an alternative to the relief of summary disposition. With that having been said, I would very much appreciate the opportunity to share the video and two angles of the video specifically with the court.
And if I may have just another brief opportunity, Your Honor. Again,
Just one
I don't see.
Let me ask you a question, and I'm coming to you, Mr. Ferguson. How long is this? How long is the video?
I've got it queued up to the moment. The relevant portion runs about 30 seconds. So I'd like to show that video from two separate angles.
All right, thank you, sir. Mr. Ferguson?
Well, again, Your Honor, I guess we can look at the video, but I don't see how that or any other evidence that we have seen here can prove fraud on the part of Mr. Preston or the alleged accomplice who committed the hit and run on the bus. And as for security for costs, that is an extraordinary remedy that is I have almost never seen imposed unless the plaintiff's case is so clearly nearly untenable that the court feels it worth imposing that sort of financial penalty on the plaintiff. And again, here, without evidence that there was actually fraud here, it's an enormous leap to say this case on behalf of affiliated is so untenable that it should be required to post security. And I'll leave it at that, Your Honor.
All right. So what seems to me is that, I'll certainly take a look at it, but especially a 30-second video rather than 30-minute. I would look at either one, but 30 seconds sounds so much better than 30 minutes. And then the other thing is that it seems to me that what Mr. Patterson is asking for, the relief on either one of those prongs, either a finding that this matter should be dismissed because of indicia of fraud, and or the security of costs. Either one of those things would seem to have to be premised upon some type of evidentiary hearing, where, because you present a 30-second video, I don't know that that is enough, essentially in isolation, to establish any particular point, unless somebody is waving signs and a flag saying that we're defrauding. I'll take a look at it, but it seems that I'm guessing that it's going to have to be contextual or something.
Your Honor, there's no waving of flags, but it's pretty close. And as a final note, the security of costs is not a financial penalty. Certainly, if we were to resolve this case through settlement, which it will not happen, or if Mr. Ferguson were to recover at trial, then he would receive any security post back. So it's not asking for a sanction. It's just saying that, this is fees and sums and costs that the city, and more specifically, the taxpayers of the city of Detroit, should not be forced to bear given the indicia of fraud. And with that said, if I may, I'd like to show the court the video specifically from two angles.
All right, I'll allow the showing of the video at this time, but just give me one moment here. Mr. Bodine, welcome back, sir. I don't see the defendant in that matter. Did you get a chance to talk with her?
I did. I'm sure she could get herself out of the breakout room. We weren't able to settle anything at that time, or come to an agreement.
All right, real good. Well, not real good, but understood. Let's see. Yeah, she's still there. Counsel, if you could go back and give her some direction, that would be real helpful. Could you do that?
Sure. I'm not sure how to help with a phone when she's on a phone though, so I don't know what the.
All right, let me deal with this other thing, and then we'll see what we need to do there. All right, Mr. Patterson, you made this time, sir.
Your Honor, I believe I need the host to enable screen sharing.
don't think you need to be host, but I make sure my security settings allow you to screen share.
There we go, Your Honor.
Yeah.
All right, Your Honor, is the video up on your screen?
Yes.
Okay, for the first time through, I'm going to emphasize the video where my cursor's at in the bottom right corner entitled rear. So, Your Honor, that is the video. It's of the actual collision itself. I believe that the court can see that and identify that this was not a accident as it is commonly understood. I would like to replay the video for the court. A different video actually isolated on Mr. Preston himself. He is the, and is this full screen, Your Honor?
Yeah.
Mr. Preston is the individual here in the red sweatshirt next to a young lady who has a cell phone out. And if I could now replay the video with this angle. So in that video, Your Honor, what we see and what we believe is a staged accident with Mr. Preston and the female with whom he's with are communicating with an individual. We noticed that they are huddling together and that the phone call terminates mere seconds after the accident. There is no surprise reaction as you might expect in a motor vehicle accident, and the call terminates immediately afterwards. So once again, Your Honor, even if this court does not find as a matter of law that there is fraud or an absence of injury, we do believe that there is sufficient evidence at a minimum to alleviate the burden on the taxpayers of the city of Detroit in defending this matter through a matter of security of costs.
And Your Honor, what I would say to that is, although I may have somewhat misspoken when I called security a penalty, it is a financial burden on a plaintiff to have to post money with the court as a condition of maintaining a lawsuit. And if the city were to be able to prove at some point that this lawsuit is frivolous on behalf of my client, it would have the right to seek costs at that time. But to require my client to pay the money up front is certainly not warranted here. And regarding the video, I didn't see anything there that I think would allow any layperson to draw an inference as to what exactly happened, much less that it was somehow a conspiracy of all of these people on the bus and some outside person who who hit the bus with a car. That is a leap across the Grand Canyon in terms of factual inference from what we've seen.
Well, yeah, it's a bit of a leap, that's for sure. It's just not enough of a nexus here for the far-reaching relief as requested under the motion for summary disposition. And certainly the issue as it relates to security for cost, the defendant city has put the plaintiff on notice that they are investigating and have investigated that this case may have fraudulent implications involved, and that as such, they would be noticing to the plaintiff that if those things prove true, that they should result in the case being dismissed, but not only that, that the city is seeking costs, that the city would like costs to be secured in advance. I don't think that there is enough here based upon what I've seen, certainly to conclude that fraud in fact has taken place in this case. I have not heard a connection between the person operating the vehicle that strikes the bus and the person sitting on the vehicle. There's indication inferentially that the person is talking on cell phones and what have you, are talking with other persons that are staging an accident with the vehicle. That is inferred. That there is nothing that establishes that through any type of electronic tracking or anything along those lines. And so the court can't really delve into any of that because it's not really before the court. So at this point, at a minimum, the motion I think is premature in terms of seeking summary disposition that would ultimately result in dismissal of the claim, and also as it relates to the requirement for setting forth security for cost at this stage. So I will deny the motion at this point. That again, in this particular case, I certainly deny was without prejudice because it seems to be that this issue of fraud may be an ongoing investigation to the extent that the city has more to work with than what has been presented to the court thus far. The court would be inclined to then set the matter up for an evidentiary hearing. In other words, if there is a motion for rehearing as relates to this motion, or the motion is filed anew and a hearing is requested, I would then set the matter up for an evidentiary hearing on the notion that council has other items to bring before the court, and I'll give a full hearing on what the issues are as relates to what the evidence is as relates to fraud in this case, and then make a decision then as to whether or not that motion should be granted and or security costs.
Your Honor, if I may, real quickly, I don't know that an evidentiary hearing in this matter in this isolated instance is necessarily feasible because of the breadth of the what we believe are connected and related cases and the potential criminal element of that. There is certainly a portion of our investigation that has some crossover there. So I understand the court's ruling as far as the motion for summary and the motion for security of costs. I would, however, ask that the court indicate in its order that the city may request costs at the conclusion of this action if we were to prevail in the matter, because fraud investigations are significant. They're substantial, and there is a significant expense as far as electronic records, phone records, depositions. And so the expense in this matter to fully and thoroughly investigate fraud, and again, it may very well exceed the value of this case, but given that it's a part of a larger issue, I would, just as a matter of lack of a better word, security for the city, that be included in the order denying the motion.
I guess I would say to that, Your Honor, I think it would be superfluous because any party always has an opportunity to request costs at the at the conclusion of a case. So in that sense, I think that whether the court includes it or not, I think doesn't really matter a great deal.
Yeah, well, I think that in my ruling on the record, I indicated that the court finds that the city has put the plaintiff on notice that it is alleging fraud and that it is engaged in an investigation in that regard to the extent that the city prevails and or to the extent that there is establishment that the claim is fraudulent in nature, that the city would be moving for costs in this matter. That would be a part of the court's order. Mr. Patterson, if you want to put that order together and send it to me, I'll sign it.
Thank you very much, Your Honor.
And Mr. Patterson, when you have an opportunity, could you contact me? I'd like to discuss this with you further outside of court.
Certainly. What is your cell phone number?
947-414-7088.
Well,
I will be seeing you, Mr. Fergustrom, in just a moment, I believe, in front of Judge Robinson.
Not that I'm aware of.
Okay. Thank you very much.
Sounds like he's making you aware now. All right. All right.
Thank you.
Yes, maybe you could clue me in as to what that might be.
It's another affiliated diagnostics case. I'm actually about 15 minutes late for that, so I have to get over there.
All right. All right.
Thank you, Judge.
All right. I have no, anybody's got any idea how I get this lady out of the breakout room? Well, she's gone. And I don't see her calling back in. Well, I have we've not been able to locate the file. And all I've got on this, I got on August 24th, the defendant's answer sent the file to the judge. And then I have set for status conference on the 19th of October. And then on the 19th, I have the matter adjourned until today's date. Plaintiff appeared on Zoom late, was given the wrong court notice for Zoom. I have no clue as to why we can't locate a file on this to really see what has occurred in this case. Just seeing if I only have a few files around. So we don't have a file. Kelsey said he did not receive the answer.
We have not received it yet.
And the lady told me that she didn't have an answer, that she didn't file an answer. So maybe that's her. Hi,
Hello.
is that Ms. Miller?
Yes.
All right, all right. So I understand that you didn't get anything worked out in the breakout room. Ma'am, you said you did not file any paperwork in this case. You just got a notice from the court. Is that correct?
Yes.
All right. So, by law, that puts you in default, and the attorney is asking, I believe Mr. Boudin is asking for entry of judgment by default at this time. What reasons do you have, or do you have any reasons upon which you want to tell me why judgment should not be entered at this time?
Why I did not do the what? I didn't hear the last part. I'm sorry.
Yeah. Do you have any reason why you believe that I should not enter that at this time?
I explained to him that we was rushed out of the property I was living in under my landlord, because it was a 4-family flat, and the whole 4-family flat was infested with bed bugs. So we had to move, and I did call DTE and let them know that I was moving. They need to get over there and turn off my service. Now, like I explained to him, I don't know if they didn't call me, give me no confirmation saying they did it or anything like that. So I moved on. I just received this saying something about it. This is the first time I heard something about it since I moved out.
All right. And so this is something about a utility bill, to the best of your knowledge, correct?
Yes.
And what you're saying is that you left there, you gave instructions for that to be cut off. Is that true?
Yes.
All right. So ma'am, well, let me ask you a question. Why did you put something in writing to the court? What you just told me, why you didn't put it in writing and send it to the court?
I did.
Oh, so you did send something to this court?
Yeah, they sent me something back saying I didn't put something on there, and I redid it and I sent it back.
Oh, okay. Got it.
Yeah.
All right. That's why, and I've asked you that a few times. You told me that you never sent anything, but now I understand why I have a note saying that you filed an answer. I got to find out what it is. All right.
So I
So-
didn't receive some paperwork stating that I need to write you guys about what's going on with the situation, and I did that.
Okay. All right. That's why the judge was not. Oh, okay. All right. So, I will set the matter up. Looks like I need to set it up for trial. Counsel, any discovery you need to do it in the interim.
We don't need any discovery, Your Honor. 60 days at the most.
All right, Ms. Miller, any information that you need from Jefferson Capital? Any documents or anything you believe that you need that might help regarding a trial of this matter?
Well, not really. I guess I can get a bill from DTE. But is it possible? I mean, I know that they're not going to do that. They say all phone calls are being recorded because I know I called down there and asked them to turn off my service at this address when I moved out. But like I said, I will call down there and get a bill or something and try to pay it off much as I can. But I explained to him I'm not working right now. I'm looking for another job, but my other job is closed. So.
All right, well, let me ask you. I know that you started out, you told me that you don't believe that you should be obligated on this bill. Are you saying that you owe something, or are you saying that you shouldn't owe anything?
I may owe something, but I don't believe it's $1,000 because when I left, like you say, I paid a bill and my bill wasn't that high. I don't know exactly when they turned it off or anything like that.
Okay. All right, so you believe that the bill should be less than $1,000, correct? Is that correct, ma'am?
Yes.
All right. So some of the stuff that's here is court costs. So if you, counsel, how much is this court cost and the statutory attorney fee in this case?
$185.78.
All right, ma'am. So, ma'am, if you were able to settle this case for a total of $185, and you had time to pay it, would you be willing to settle the case at that number?
Yeah.
So, counsel, the ball is in your court as to whether your client would be willing to enter in that settlement. She says that she left and she told them to cut it off, and they may have stayed on a little bit longer. She believed that her number was under 1,000. She's paid something already. She's willing to pay $1,185 if she's given a payment plan to do so. So I can set another date, or you guys can try to talk about that now to see if you could resolve it on that basis.
I mean, think she also stated she didn't have any money to pay anything at this time, so.
No, I'm not working right now.
Yeah, so the next thing that we would have to talk about, ma'am, is I could set up some type of installment payment, but you'd have to have a monthly amount that you would, once you paid the monthly amount, then no actions would be taken against you to collect. And we could start at one amount, and then in 90 days or 6 months, I could look at it and see if that amount should be increased and try to get this taken care of.
They start off.
I'm sorry, ma'am.
I say you said start off with what amount?
Yeah, you tell me, what could you put towards this on a monthly basis, ma'am?
Well, right now I'm not able to, like I say, do anything because I don't have an income. But I'm hoping and wishing I have something by next month.
Right. So if I put it on a payment plan, that how we do that is real significant, because if you don't make payments, then that's gonna result in then certain actions being taken to come against assets and things like that. So here's what I was thinking. My thought is, ma'am, that if you want to enter into agreement today, then the court gave you till January 7th. It's the first Friday in January. You pay $100 at that time, and then after you would pay $75 a month until you got this taken care of. So $100 in January, $75 a month in February.
I can try to make it possible. Hopefully, if I find me an income.
All right. So what are you relying upon now? You have some type of disability or something, man, or some type of alternative resources?
No.
Okay. All right. So I don't want to put any kind of payment plan in place if there is not a mechanism for doing that. So the question now becomes, Counselor, if there is a willingness to stipulate to entry judgment at 1185 at this point, and then, ma'am, when you get income, you could file a petition for partial payments, or the plaintiff will be in a position where they have a judgment where they could seek to find if there's any bank accounts or anything to try and collect on the judgment.
Okay. I'm no bank account.
So, counsel, it's to you again, sir.
I'm not able to just agree to a judgment for a lower amount than we're requesting, Your Honor.
All right, thank you, sir. All right, so what I'm going to do now is, given that there is something of an answer that's been filed in this matter, I will set the matter up for a bench trial date. I'm going to set that date. I'm going to go ahead and set that date in January. I'll give you a good date.
Is it bench trial?
Yes, that's sure.
January the 24th.
January 24th, 2022 at 10 o'clock a.m. In the interim, counsel, I'm going to order that any documents that are predicates to the obligation that those documents, copies be sent to Ms. Miller. And Ms. Miller, you guys be ready for the trial of this matter on January 24th, 2022. You'll notice in the mail with that date. Make sure that you are on Zoom at that time. Understand?
Yeah.
All right. All right.
Are
Thank
you
you.
are you vacating the judgment that was entered?
Sorry.
We received an entered judgment. Are you vacating that?
I have no indication that a judgment was entered. I have answers sent to the judge on the 24th of August. I do have on the 27th, the default sent to the judge for review. And that's where the register of action stops. All right, so I'm vacating the judgment at this time and setting the matter for trial.
Thank you.
All right, thank you. All right, see you at the next hearing. Good day to you.
Thank you. Have a good day.
All right, thank you, Madam Reporter. What a mess that was.
Excuse me, Your Honor, the reason I wasn't talking is because I'm, I had to mute it because the officer said I had too much noise in the background, so that's why I was muted to make sure I got everything.
Oh, perfect, perfect. All right.
How's the family?
Now, everybody's good.
Oh, good. Tell them I said hi, and I'm so proud of Rebecca. I am so proud of her.
Thank you. So you know about how proud I am, right?
Yes, I do. Yeah. Yes, I do. So we're all set?
We're all set. All right.
Yeah.
Have a good day.
Thank you and a good holiday.
Likewise.
All right. Bye-bye.